Good morning. We are live. This is Attorney Vince Davis, and this is The Secret, How to Fight CPS and Win. Today, our guest unfortunately forgot that he had church today, and so he will not be appearing with us. And instead, we'll do an abbreviated show and answer questions from the audience. In the meantime, to let the audience get going and start asking questions. You're going to ask your questions by posting them in the comment section. We'll play a couple of shorts and ask for you guys to post questions, and I'll answer those questions. So here's the first short. Trial is fast approaching. Are you and your attorney ready for the trial? Have witnesses been subpoenaed? Has exhibits been subpoenaed? Has the witness list been prepared? Has the exhibit list been prepared? Have the trial briefs been prepared? These are all questions that you need to know the answer to before you go to trial in any CPS case. CPS cases are just like other cases. There should be preparation, and you should sit down with your attorney, either in person, by phone, or Zoom, or something like that, and discuss the strategy for your case. Don't wait until the day of the trial to talk to your attorney. Be proactive. Contact your attorney by phone, text, email. Talk to your attorney. These are your children that we're talking about. Make sure that you and your attorney are prepared. Ask them, have the witnesses been subpoenaed? Ask them, are the exhibits ready to go and be introduced? Call me if you... Let me give you some tips on how to talk to your prospective CPS attorney or even your CPS attorney when you speak to them in person or on the phone. The first thing you want to tell them is not a story of your case. Do not tell them that. Put a fence around the story of your case before you tell the story. Be ready to tell the attorney the posture of the case, where you're at in the case, the next court hearing, and what type of hearing it is. And then, if he or she has the time, you can tell the story of the case. A lot of times, the story has no impact on the different phases of the case. I know that sounds strange, but each phase in a CPS case is different from the previous phase. So what happened 2 phases ago may not be relevant now. Call me, 888-888-6582. Okay, good morning, everyone. Our guest is MIA. Actually, I did talk to him. He forgot he had an obligation, a religious obligation this morning with his family. So he wanted to be rescheduled. So we're going to use this time to do question and answer today. If you have any questions, go ahead and post them in the comments. Or if you want to be on live with me on the stream, just go ahead and post your email address, and I will send you an invite. Okay, I haven't gotten any questions yet, so I'll play another video, and I'll start answering questions when everyone decides to post their questions. In California, hearsay rules of evidence in juvenile dependency or CPS cases is different than a regular criminal case and different from a regular civil case. For whatever reason, the California Supreme Court and the legislature of California has ruled or made law that hearsay used by a social worker can be used against you in a proceeding. The reverse is not true. You are not allowed to use hearsay in a proceeding against the social worker. Now, there are a lot of exceptions to the hearsay rule, and in California, there's hearsay, which is an out-of-court statement used in court to prove the truth of the matter therein. There are many exceptions, but when you're coming to lay out your case and strategize your case, remember, you have to fall under one of those hearsay exceptions in order to use that important evidence. Call me if you have questions. Okay, our first question is from YouTube. Hey, you guys. Who's watching on YouTube? Hey, you guys, make sure you like and subscribe to the channel. She says, hi, Vince. My brother just won his appeal. He filed after his rights were termed. He won due to the agency's social worker not complying with the Indian Welfare Act. What does this mean? All right, that's actually a very good question. There is something in the United States called the Indian Child Welfare Act. It's a federal law that applies to all of the states. And it was enacted to provide special protection for American Indian children. So if you are in a state or in a county here in California and they file against you and you have American Indian ancestry, not even full, just maybe even a little bit, depending on which tribe you're from, the tribe has the option of taking over the case or to be involved in the case. And when this happens, the laws that are used are substantially different from the state law. It's harder to remove a child from an Indian family. And there are a lot of rationales why Congress made this law. Um, so I won't go into that, but uh, suffice it to say that there are special things that you have to do with an Indian family, and you have to give certain types of notice. So, hey, you guys, I'm involved in a case right now up in Northern California where they lost parental rights. It was appealed. One of the issues on appeal was, did the county ever satisfy the ICWA, Indian Child Welfare Act, requirements of notice? And the Court of Appeals ruled that they hadn't. They reversed the termination of the appeal, excuse me, of the termination. They reversed the judge's decision to terminate the parental rights of the parents and sent it back to the trial court with instructions on what to do. And we're currently involved in that particular issue right now. And we're trying to get the tribe involved, and hopefully, um, the tribe will get involved and the parents won't lose their parental rights. Hey, you guys goes on to say his case has been narrated to go a certain way in order to protect the social worker who illegally removed my niece the year before. I have evidence of the corruption, none of which were brought up by his attorney. That's exactly what happened with us. Well, hey, you guys, you might want to consult with a private attorney and try to find out what can be done. There might be other things that can be done. Um, if you have evidence of corruption, um, you might want to make a motion to the court. You might want to bring up some type of federal lawsuit, etc., etc. So, hey, you guys, don't just wait. Don't just wait and do nothing. Do something. Okay, here's Michael Renteria. I apologize for being MIA. We have church at 11:15 and didn't think about that when scheduling our video for 10:15. I will be back. Thank you. Hey, Michael, I appreciate that. I appreciate you posting that. I wasn't going to mention your name. I wasn't going to out you like that, my man. But thank you, and we look forward to having you back on the show, on another day or another time when you're available. So Carolyn writes, how do you check? My mom said her grandmother was full-blooded Cherokee. That's a really good question. The first thing, and this seems kind of corny, you can get one of these DNA tests, right? And you can find out the area or the region you may be from in the United States with regarding to American Indian ancestry. And this is what we're doing in that Northern California case right now, we're contacting all the possible tribes and seeing if they want to be involved or should be involved in the case. And if one of them says yes, well, we're probably going to get these kids back in the family, and the kids will not be adopted out by strangers. Congress, for whatever reason, I'm not saying it's right or wrong, has decided that to pass something called ICWA, ICWA, Indian Child Welfare Act. And it's a federal law that takes precedent over any state law with the issue of American Indian children. Okay, they have to be treated differently, or there are different laws that are being applied. So, what I would suggest, Carolyn Fowler, watching on Facebook, is that you start contacting Cherokee tribes in your area, or not even in your area. You know, you may be from a different part of the country or a different state. So that is the way that you can find out the DNA test, and also contacting the tribes. It should be very easily to test, you know, one of the parents to see if they have American Indian ancestry, and if they do, that means by definition the children do, and it means by definition that the Indian Child Welfare Act might apply, giving you substantial protection from county and state social workers. I mean, it's a really big deal, Carolyn. Hey, you guys goes on to say his case has been okay. We read that. Um, Mari watching on YouTube. Hey, Mari, good morning. Mari Wilson. Mari, I hope you like and subscribe to that YouTube channel. Mari says, we are fighting the adoption, saying my kids are unadoptable due to bonds shared with me and behavioral issues that persist. What are some of the ways to prove the bond? Mari, if you're in California, perhaps in other states as well, the way to prove the bond is to request a bonding study by a psychologist or psychiatrist. And that person evaluates the bond, comes to court, and testify. I'd have to say, in my experience, in every case where the psychologist has said there was a bond where it would be detrimental to terminate the rights of the child from the parent, the judge has gone along with it, except for in one case. One case, the court-appointed expert came to court and said that, and the judge still terminated. The judge did not give that expert that opinion the weight that I think should have been given. Judge gets to make the decision. In this case, he was wearing the black robe, and we appealed it, and it was upheld on appeal, unfortunately for my client. All right, Ashley watching on YouTube. Ashley, don't forget, like and subscribe to the channel. I am in the process of an appeal, and I'm waiting for the county to file their response. But my lawyer has filed Indian Welfare Act and denied a bonding study. Does it go back to the dependency court? If you win the appeal, most likely it will go back to the dependency court. Okay, so good luck on that appeal, Ashley. Hope everything turns out for you. Oh, hey, you guys. Can we bring these issues up to the court now that he won his appeal? The answer is absolutely. You must bring them up to the court. These issues weren't allowed to be brought up during the appeal because we weren't brought up previously in court. That's generally what happens. You are limited. The general rule is, at least here in California, when you appeal, they must be on issues that you brought up in the trial court. In other words, you can't lose in the trial court, think of a whole new legal argument, and bring that up on appeal. You're limited generally to what was argued in the trial court. So, to that extent, hey, you guys, your appeal is limited. Mari's back looking on YouTube. Mari, don't forget, like and subscribe to our channel. My attorney has said nothing about a professional doing a study despite me bringing it up. Well, Mari, I'm not sure what to tell you. You might want to write an email, something in writing to your attorney saying that you request or demand that they make a motion for a bonding study for you and the child. Because that's, in my humble opinion, in most cases, not all, but in most cases, that's the only way you can win that. You need to have a professional come in and say, that bond between the parent and the minor is so strong that it would be detrimental to the minor to terminate the parental rights. Have I ever seen that work and happen? Yes, I have. Yes, I have. Carolyn says, thank you. Oh, you're quite welcome, Carolyn. Lindsay Lee watching on YouTube. Lindsay, don't forget to like and subscribe to the YouTube channel. Lindsay says, CSB is allowing my daughter to live in a home as someone who, although was a juvenile, he sexually assaulted a 5-year-old. That's basically, Lindsay, in California, that's a no-no. I would guess that it's the same in all states. You can't place a child with someone that's a pedophile. I was a victim of domestic violence, and that's why our case was open. Well, let me ask you this. Is the person that she's placed with the father? Because that puts a little extra twist on it, And then, of course, there's the allegation that he sexually assaulted a 5-year-old. I mean, was he convicted of a crime? Was he, this proven in court? Is this some kind of rumor? Is it something everybody knows in the community? So those are the things that you have to take into account, Lindsay. If he's the father, you know, there might be some basis to placing the child with him, unless the social worker files a case that says, he's a pedophile and he can't have children in his custody, right? Okay, Lindsay goes on to say, I got to keep my kids initially, and then I didn't get them into daycare until they removed them. Well, Lindsay, I don't think getting children into daycare is a condition for your children to be removed. So I'm wondering, you know, I wonder if there's more to the story. Lindsay goes on to write, they also had knowledge that a active drug user without a driver's license and a warrant for overdosing in his vehicle was driving my son to his daycare, and it took them 3 weeks to address it. Lindsay, I don't know what all of the facts, but that's highly unusual. Highly unusual. Mari Wilson's back. What is the likelihood we will win without the study? And if we win, what is the next step? Okay, Mari, that's a tough question you're asking me to answer when I haven't seen the file, right? I don't know any of the facts of your case. But let's just speak in general terms. What is the likelihood that you will win without the study? The likelihood of you winning without the study, in my opinion, is very low. Very low. And then it says, if we win, what is the next step? If you win, and the next step is the court has to pick another type of permanent plan for the child, which is generally legal guardianship or long-term foster care. But with those two, you still maintain your parental rights, and you still have the opportunity to come back in the future to try to get your child back. Okay. Analyzer Fields, watching on YouTube. Analyzer, like and subscribe, please. In my case, in my Utah case, my husband, military brat, and his half Cherokee, the court denied it. Denied what, Analyzer? I'm not sure what you're referring to. If you're referring to denied your appeal or denied ICWA, you should be appealing that or going to federal court, because no state or county is allowed to ignore ICWA. Lindsay goes on to say, it's my brother. Yes, I have paperwork to prove it. The family of the little girl provided me with that. That seems highly unusual. Lindsay Lee, I think there's more going on there. The caseworker said he can't be left alone with her. Well, if the caseworker said that, that means she's acknowledging that there was a problem. I'm not sure I've ever heard of a social worker placing a child with someone who's a known pedophile. I've seen a lot of crazy things, but that one I haven't seen in my 30 plus years of doing CPS cases. Lindsay goes on to say, oh, that's 1000% the reason why they were removed. Well, Lindsay, you need to talk to your lawyer. If they were removed because you didn't put them in daycare, there must be something else going on that you're not mentioning, because not putting kids in daycare is not, in my humble opinion, is not a basis for removing your kids. You might want to seek some appellate remedies if that truly is the only issue. Hey, you guys watching on YouTube, can my brother request a new public pretender due to the lack of representation of the first go round? Answer is yes, especially if you're in California. I have a YouTube video on that, on how to request a new um, public defender. It's by way of something in California called the you make a Marsden motion, Marsden, I believe is how it's spelled. Search YouTube on my channel, and I have a video exactly how to do that. Now, here's the thing. Hey, you guys, here's the thing. Just because you make a Marsden motion does not, I repeat, does not guarantee that the judge is going to grant the motion and give you a new public defender. Okay? Most of the time, people make Marsden's motions and they do it the wrong way. They either do it with no facts, number two, without admissible evidence, and just making conclusionary statements. Oh, I don't like him. He doesn't do this, and there's no facts. You got to have the evidence if you want your Marsden motion definitely granted. Okay, Analyzer Fields watching on YouTube. Analyzers, please like and subscribe. Because they said father wasn't registered to the tribe and the Cherokee is primarily maternal, and my mother-in-law is a third but not registered. I don't know who you refer when they say they. Generally in my office, I try to use a rule. We don't use pronouns he, she, we, they. I don't know who you're referring to. But if you're referring to the social worker doesn't make that determination. The tribe does. Some tribes require what they call it, a quantum percentage of American Indian ancestry before they say, yes, you can be in the tribe. Some tribes say 1 drop rule. You got 1 drop of our blood, you can be in the tribe. So that's something that the tribe decides from tribe to tribe across the country. Social workers don't describe that or don't determine that. Hey, you guys, who pays for the bonding study if parent requests it? Good question. It depends. I know that's not a good answer, but that's the truth. Generally, when we make bonding study motions, we ask the court to pay for it. Here in California, anyway. Now, that doesn't mean the court's going to grant it. And sometimes I ask for the court to pay for it. And if the court doesn't pay for it, to give my client the opportunity to pay for it. And then sometimes the judge will order it. Yeah, I'm going to grant the bonding study, but mom has to pay for the bonding study. So it just depends. Okay, Jamie Clark watching on Facebook. Good morning, Jamie. Hello, much love and light, Mr. Davis, Indy, Miss G, and the whole gang, and prayers to all. Well, thank you very much, Jamie. Jamie, I don't know if you know this, but I forget what days of the week at 8 p.m. It might be Wednesday, Thursday, Friday. Miss G does a prayer show. You might want to check that out, 8 p.m. on these same platforms, Facebook and YouTube. All right, Lindsay goes on to say, oh, yes, she absolutely knows about it. It is my mother's house. She was placed with my brother lives there. Again, Lindsay, that's highly unusual because if your brother does something to this child, that particular county or state is going to be in a bunch of trouble. Money-wise, they're going to be sued. Jamie from Facebook says, I have seen it. Someone I know is on Megan's list. You're allowed to have children in this state if you're on Megan's law in Pennsylvania. Wow. That's all I can say about that one, Jamie. Wow. If you're a known child abuser or pedophile and you can still have foster children, that's hard for me to believe, Jamie. That's hard to believe. Because if something happens, somebody's going to be sued. Lindsay says, I am not leaving anything out in regards to the removal. It's insane. Absolutely insane. I've done nothing wrong. Lindsay, talk to your lawyer about appellate remedies. If you're in California, appeals and writs is what you need to do. And you need an attorney that, practices in this area, doing those types of things. Lindsay says, I've never been in trouble, never used drugs, passed all the drug screens, provides that. That's the reason I can even send you my paperwork. Oh, Lindsay, I appreciate that, but I got a lot of paperwork I have to review just for my clients. You need to talk to your lawyer. You need to talk to your lawyer and try to work out something, some type of strategy to get the child back or children back. Lloyd, watching on YouTube. Lloyd, please like and subscribe, my man. Good morning. Attorney Davis, do social workers have to verify their investigation with their legal department before attempting to take your child or your children? That's an interesting question, Lloyd. In California, uh, I would say generally no, although they don't share with me how they procedurally do things with us in the office. Before this week, I would have said generally no, but I'm involved in a case right now where the lawyer is involved and they're trying to figure out what to do about detaining the child or not detaining the child. So sometimes they are, sometimes they're not. Analyzer Fields on YouTube. What is the statute for appealing the removal for parental rights? Well, Analyzer, if you're in California and your parental rights get terminated, you have 60 days to file a notice of appeal. Okay. And generally that's not really a statute of limitations, but that's the deadline. I hope that answers your question, Analyzer. All right, good morning, Amanda Lynn from Facebook. What do you do when your case has been confirmed illegal from the opening via detective and state police, and it has been 120 days, and many criminal, not civil, have been broken? You call Johnny Cochran. That's what you do. You get a good lawyer to go to court to sue these people for what they've done to you and the violation of your rights. Amanda goes on to say, do you know of any attorneys who will take a case on in PA where cynical law was broken on many counts as well as civil? I'm not sure what you mean by cynical. Maybe you meant criminal. Unfortunately, Amanda, I don't know anyone, let alone attorneys, that lives in Pennsylvania. I was hired recently to do some consulting for an attorney back in Pennsylvania, but that's just on general, strategy and things of that nature because I'm not licensed in Pennsylvania. Okay. Hey, you guys. The judge termed my brother's parental rights on the grounds of, quote, no bond. Excuse me. Never knew of bonding study when he lost his parental rights. Hey, you guys, I'm not sure what to say. That's something you had to take up with the attorney or take up with the Court of Appeals for, in California, they call it the ineffective assistance of counsel. All right. Jamie Clark watching on Facebook says, I know I watch it, Mr. Davis. This is strong. I was on your show, Laugh Out Loud, aka Jessica. You didn't reach out to my lawyer yet, but she's waiting, she said. LOL. Okay, that must be some kind of inside joke. Okay, hey, you guys says existed. It's a Commonwealth state. They do what they want. Jimmy, it doesn't matter whether it's a Commonwealth state or not. The law is the law. And if you're referring to ICWA, that applies to everyone in every state and county in this country. Lindsay says, I know. Oh, it's crazy. I know, but it's the truth. Jamie says, it's true. It's true. Not just foster children in general. It's hard for me to keep up with all of these questions on the different platform. Amanda from Facebook, Megan's Law, as long as you are not judge sentence against children or stipulated yet can be around children. Sex offender and pedophiles are not the same, but they are on Megan's Law. Okay. Didn't know that, Megan. Didn't know that, Amanda. All right. Lindsay Lee, I'm in Ohio. Okay. I have two attorneys. We have a motion filed and a hearing June 2nd. Good luck on that hearing. My lawyer said that we need to get the children back first, and then we will file a lawsuit because of everything that has happened. Your lawyer sounds like he knows or she knows what they're doing. Amanda Lynn, who's Johnny Cochran? I will call. Amanda, that was a joke. And just to tell you, you're probably too young to even realize this. Johnny Cochran was one of the greatest lawyers that ever practiced law in the United States. He was a lawyer here in California. He was the lead counsel on O.J. Simpson's case, People versus O.J., when O.J. was accused of killing two people, and he got O.J. off. But he was famous before that and famous after that. I think Saturday Night used to have skits with a Johnny Cochran lookalike, but one of the greatest attorneys ever to practice law in the United States. All right. Oh, and Amanda, I'm sorry to tell you this, but he's deceased. Many years ago, he passed away of I think it was brain cancer. Hold on, you guys. But whatever it was, he was yeah, he's deceased now. His firm still lives on, and they do a lot of different things. Um, None of the attorneys there were as famous as Johnny was. Let's see. Okay, hey, you guys has a question. How common is it for other social workers to go against investigating social workers' decision not to remove? How common? Not very. A staffing meeting was held in order to get my nephew removed. A revised version of original report, changing all positive remarks about my brother to negative remarks. At a meeting with the ombudsman investigating social worker, asking her why she revised the report, and she what? Never seen that revised version of a report, let alone write it. I'm not sure the question you're asking. Hey, you guys. I apologize. And I apologize to you guys. The comments, we're on like 8 different social media sites, and the comments are coming fast and furious, or the questions. Amanda says, I read the General Assembly. I'm weird. Jamie, yes, there's a difference, but still that wicked either way. It was against a child, so they shouldn't be around children at all. Amanda, OJ's lawyer. Right. Now you remember. You probably, I don't know if you were born or you were probably a child when the OJ Simpson case was going on. I laughed at the Johnny Cochran joke. And then Amanda says, I'm autistic. I don't get jokes. Sorry. Oh, I didn't mean to offend you. I hope I didn't offend you, Amanda. All right. So everybody's now chiming in on the Johnny Cochran. If it don't fit, you must acquit. That was the saying that Johnny Cochran made, who became famous in the O.J. Simpson trial. He's talking about the glove that they found with the bloody glove. Apparently, didn't fit Johnny in the courtroom uh, demonstration by one of the prosecuting attorneys. Bible speaks. Do you practice in Texas? You know, I haven't done a case in Texas. I've done some consulting with attorneys down there. But if you wanted me to go to Texas, you could give me a call. There's something called Pro Hoc Vice that allows me to practice in other states, case by case. Oh, Amanda confirms she's not offended. Perfect. All right. It's slow. The comments are coming in way after you talk about something and we respond. Jamie, I apologize for that. Grace isn't working today. It's Sunday, and it's hard for me to do the show, answer the questions, look at eight social media sites, analyzer, same answer as before. I'm not licensed in Utah. I have consulted an attorney in Utah about a case. I have a client right now that lives in Utah, but her case is in California. But if you're interested, give me a call and we can talk about getting me admitted pro hoc vice just to do your case in Utah. Bible Speaks. Okay, Bible Speaks says, what number do we call? Bible Speaks. Look at this thing, the screen. Bottom right, you see a number. 888 And then you see my name under my chin, Vince Davis, 888 You know, I'm wondering, a lot of people ask me, "Hey, what's your phone number?" And I'm thinking I got it in two places on the screen, and I'm wondering if you guys are seeing the same screen that I'm seeing. Uh, okay, Jamie, thank you. I appreciate that. Bible Speaks. Thank you. Okay, Lloyd's back. Attorney Davis, it is a civil rights violation. Is it a civil rights violation if the social worker added allegations without any evidence to reinforce their case to obtain a warrant to remove my children? I would have to say, Lloyd, yes. I mean, of course, I don't know all the circumstances, but that would be my guess. I mean, for someone to just make allegations against you without any evidence, that's coming very close to the line, you know? Does that happen? All the time. Make the allegation now, we'll prove it later. Or at least we'll make it up and prove it later. All right. Listen, folks, as I said earlier, we were missing our guest for today, and I was just going to do some question and answers. So I'm going to call it a day for everyone and tell you next week we're going to be on at 7 p.m. Pacific Standard Time. So please come with your questions. And if you want to be a guest, call 888 and ask for Grace. And they will leave Grace your name, your number, and your email. And we will arrange for you to be a guest on the show. So until then, have a good day today and have a good rest of the Sunday. And we'll see you guys tomorrow at 7 p.m. All righty. Bye-bye.